We're just coasting along on 4CRB.
And a very good morning to you. This is John Fradgley from the Bell Legal Group, back with you for another program of The Law and You right here on 4CRB. Your opportunity to get free legal advice between now and 9:30, that's 10:30 Tweed Coast time. All we ask you to do is get on that telephone as soon as you possibly can. 55208888 is the number. That number again, 55208888. South the Tweed River, don't forget to put 07 in front. Or if you want to email us, you can at talkback@4crb.com. That's talkback@4crb.com. And we already have one very patient caller online. As we say, a very good morning to Barry. G'day, Barry. How are you today?
Oh, fine, thank you. Is that John?
It is indeed. How can I help you today?
Thank you very much for speaking to me.
No trouble.
My problem is my granddaughter, actually. She bought a ground floor unit, and there's one unit above. She bought it 12 months ago, and there is little or no acoustic insulation in the ceilings. We've removed the fans and had a look, and there's nothing there. She's had 12 months of hell. You can only describe it as that. And they admit it, and yet here we are 12 months down the track. They still haven't done it. Can we sue them, or what can we do about it, John?
So was it a brand new unit that she purchased?
It was brand new, yes.
Mm-hmm. So she purchased off the plan?
Yes, she did,
right.
Yes.
And what's the nature of the floor between the two apartments? Is it a concrete floor?
No, it's not. No,
it's timber.
She has plasterboard, and then we've removed the fan, and there's plasterboard and wooden flooring above.
Right.
So you can imagine it's just nothing there at all.
Yes.
And there's nothing in the cavity.
Right. Have you spoken to the Queensland Building Services Authority?
Well, she's doing it at the moment. You know, she got in total desperation. The builders admitted it and came round about a week ago and did a lot of banging and hammering, and she said it's exactly the same. They haven't done anything. I don't know what they were doing up there, but...
Yep.
But
what they would really need to do, I have some experience with this through a completely unrelated situation, Barry, but many years ago when I was an article clerk, our office was in a building in Surfers Paradise, and there was a dance studio on the floor above us, which made working at night very difficult because you had the sound of the dance steps going on. And so the landlord there ended up putting... and that was a concrete floor between the two floors, so I can only imagine that timber would be worse. But the landlord ended up putting an acoustic barrier between us and the floor above, and it was quite, from memory, it was around about probably 45 centimetres in depth. And it was a full baffling with soundproofing material contained within that wooden frame and then plastered over with a new ceiling. So I think the Queensland Building Services Authority is now called the Queensland Building and Construction Commission. So I would certainly be having a word to them. The other thing that strikes me, and it's a problem that someone was talking to me about the other day, and that is in relation to how buildings are now certified, and the fact that many of these are done by private certifiers, and sometimes the proper regulations may not be fully adhered to. So the other point of contact for her, Barry, may be is it the Gold Coast City Council?
I think so, yes, or Logan. I know it's one of those.
Yes, well, I would be getting onto the council also. Because the council should have minimum standards for these sorts of things to ensure that there is soundproofing between two floors, particularly when the floor is wooden. And I know that it is possible to do because we built a home probably about it would probably be getting on for about 10 years ago now.
Right. And
it only has, it's 2-story but has a wooden floor. And I know that's one of the things that my wife was very particular about, to ensure that appropriate soundproofing was put between the two levels. And I can tell you that in the downstairs area of our house, you cannot hear anyone walking around upstairs at all. So
her problem is that the people upstairs get up at 4 o'clock every morning and do tap dancing, you know.
Oh, that might be where that dance studio from above
It
us
must
went.
be. Did they actually remove the ceiling then?
Sorry?
Did they remove the ceiling where you were then?
Well, of course, in the building we were in, it was a concrete floor. And so the concrete floor, what they did was they actually added a ceiling. Below the concrete floor. So they put, I think from memory, they put these metal braces into the concrete floor itself so that they hung down to support a frame. They then framed that up. They then filled that with baffling material.
Right, yeah.
So insulation. And it certainly, look, it wasn't perfect, but it was certainly infinitely better. You could actually work at night without the sounds.
Yes. Can she sue the builders at all for absolute 12 months of hell?
Well, look, it would be very difficult, Barry. I would certainly not recommend that she enter upon suing anyone lightly. No. I have often said to clients of mine who are looking at suing people, I as a lawyer would be very reluctant to sue anyone because the cost of litigation is so high.
Right.
And as a lawyer, you think I'd be able to afford it, but even I would be reluctant to do it.
Okay,
but what I would suggest she do is look, if she's up at Logan, then it may be a little more difficult, but look for a local community legal service in her area who provide free legal advice, and she could go along and speak with them in relation to it, because one of the things that you would need to look at is the contract by which she purchased the property, whether there were any plans attached to the contract, etc. All those sorts of documents would need to be looked at to determine what course of action, if any, she may have available. But as I say, the Queensland Building and Construction Commission and the local council would be my starting points.
Okay, then.
All right, then.
That's very, very kind of you to speak to me.
Okay, then, Barry. All the very best.
Thank you, John.
Bye now. And the time on 4CRB just coming up to 13 minutes past 9. The Law and You is the program, 55208888, the number if you have a question or a query. Just like Brenda. Good morning, Brenda. How are you today? Brenda, are you there?
Yes. Hi, John.
How are you today?
Very well.
That's good. How can I help?
You answered my email last week about the refund on the GAN.
Yes.
And I just had another question.
Sure.
They're asking for my bank details to pay me their offer of the GAN trip only.
Yes.
If I give them my bank details, can I still continue negotiating for the off-train excursion?
Have they said that the amount they're going to pay you is full and final settlement?
They said at this time.
All right. Well, if they've said at this time, then yes, I don't think that closes the door.
Right.
There's a common thing that is used in cases where there are disputes about sums of money. And if we were sending an offer to someone saying, say the claim was $1,000 and the client only thought they should pay $500, we would send a letter which enclosed the cheque, for example, and we would say that this is full and final settlement, and negotiation of this cheque will be deemed to be acceptance of the terms on which it's offered, namely full and final settlement, because then you create an estoppel. So if there's no language, if they've said just simply, settlement of the GAN at this time, and they're not saying this amount, we'll pay you this, but it's in full and final settlement of all claims, then I think you're okay to accept that amount.
Thank you so much.
Okay.
Thanks,
then, Brenda, all the very best with that.
Okay, bye now.
Bye now. And the Law and You is the program, 55208888 is the phone number. We presently have no callers online, which is a stark contrast to last week where we had calls just coming in thick and fast. I think from memory we took 8 calls last week, and one caller gave up in frustration, Tony, from memory, which I'm very sorry about. So, Tony, if you happen to be listening today, by all means give us a call. You'd be able to get straight through, and I'll take your offer straight away. We'll be back after this word from our sponsor.
Here's an amazing exclusive travel offer for 4CRB listeners only. Doug from our sponsor Cost Less Travel has great deals on a 15-day European river cruise in June of this year. Twin cabins from $3,498 per person and single cabins for just $3,998. Enjoy 15 days of relaxing luxury cruising, including meals, drinks and excursions from Amsterdam to Budapest, taking in Cologne, Nuremberg, Bratislava and Vienna along the way. Add an airfare from $1,298 and you're there. This is a one-off unique deal only for 4CRB listeners, and for every booking, Doug will also cover your next 5 years Radiothon subscription. Great for you and 4CRB. Call quickly before time runs out and ask for more details. Cost less travel. They really do cost less. Phone 1300 55 7388.
And you're in tune with the Law and You on 4CRB. Your opportunity to get free legal advice by calling 55208888. That number again, 55208888. As we say, a very good morning to Rose. G'day, Rose. How are you today?
I'm very well, thank you.
That's good. How can we help?
Just a general interest query. In a situation where there's 3 siblings and one dies and she leaves her estate to one of the 2 remaining, Chinese whispers tell them that the other person can't contest it. Is that accurate?
It is. Basically, the only people who can contest a will are the spouse of the deceased, a child of the deceased, or someone who was financially dependent upon the deceased at the time of death, and normally a minor. So people like grandchildren, brothers and sisters don't have any claim. The only time that you might be able to make a claim would be if, for example, you had evidence that the deceased, for example, had a previous will which left everything equally to the other siblings, but they were under duress from the person who ultimately benefits, or alternatively, if they were of unsound mind and there was an earlier will which left everything to the other siblings, or even if they were of unsound mind or under duress, and so therefore the will could be questioned, and there was no earlier will, under the rules of intestacy, it may be that the living siblings would benefit. But certainly, in Queensland, a sibling can't make a claim merely because they're a sibling.
Oh, okay. Thank you. This lady was never married and just a single lady.
Yep.
And she left it to one of the siblings. So,
yes.
Oh, well, that's good.
Yes.
I appreciate your time.
Okay, then.
Thank
all the very
you.
best, Rose.
Yeah. Bye-bye.
Bye now. And the time on 4CRB is 18.5 minutes past 9. That's past 10 Tweed Coast time. One of the subjects that I was going to talk about today while we were waiting for more calls to come in was the question of when an advance health directive might be an appropriate document to have. It particularly came to mind for me in reading an article in the Courier Mail on Saturday about the former Premier of Queensland, Campbell Newman, in relation to the passing of his mother, Jocelyn Newman, who sadly contracted Alzheimer's. That article was more about the wisdom or otherwise of euthanasia, but nonetheless it did raise this issue of advance health directives and when they are appropriate. But we have another caller online, so we'll just take that call first and then hopefully we can get back to that discussion. Good morning, Eric. How are you today?
Oh, good morning. Very well, thank you very much.
That's good. If you've got your radio on in the background, Eric, might be an idea to turn it down.
No, I'm just driving at the moment on hands-free.
Oh, right, okay. I could hear a bit of feedback, so I thought it might have been the radio. That's fine. How can we help you today?
Look, I live in a house that's opposite a very large in Brisbane, a very large public hospital where the helicopters land and fly directly over my house. Now, I've been living there about 30 years, but this infrastructure's only been there about 10 years. And every time they fly over, which is sometimes on weekends, could be 3 or 4 times a day, they fly over very low and the whole house shakes, you know. My pets are absolutely terrified. I've written to Air Services Australia, and they say, "Oh, sorry, it's emergency helicopters. We can't do anything about it." Now, there's no reason why these helicopters that approach the helipad can't can't bear slightly to fly over the adjacent industrial area without losing any time. I'm very concerned about the damage to my property and the extreme noise. You know, they fly over at about 100 metres or so.
Yes.
And everybody I speak to says, I'm sorry, this is an emergency situation. There's nothing we can do. But, you know, a matter of 2 or 3 seconds diverting over the industrial buildings would not cause any emergency deterioration at all.
Yes.
Have you got any suggestions of what I can do? Because the whole house absolutely shakes. You know, the walls, the timber house, if it was a brick house, I'm sure there'd be severe cracking. Thankfully, it's a timber house, and so that absorbs some of the vibrations.
What I would suggest you do, Eric, is write to the operators of the emergency services, the helicopter service. Normally they're Westpac or someone like that, so if you can find out where they are, I would suggest that you either write to them or see if you can ring the general manager of that emergency service and see if you could make an appointment to go and see him to see if it is possible to get them to change their flight path. Some of these things are often determined by wind direction, of course, and I do know, for example, we've had an extraordinary period of months where winds have predominantly come from the north-northwest, which is quite unusual for our area where our winds are predominantly from the southeast, and I've got no doubt that that's part of the reason why we've been experiencing these high temperatures. But the one thing I've noticed with the wind direction being predominantly from the north is that the planes landing at Coolangatta Airport are landing from the south, which flies over my home. So I notice the aircraft going over, whereas when the wind's blowing from the south, they're landing from the other direction. So I would suggest getting onto the general manager of the emergency helicopter service, seeing if you can go in and see them, and even if you were able to take in a plan, a Google Maps plan or something to show how it would be possible for them to approach the landing area without flying over residential property, I would be very surprised if they wouldn't be receptive to that. But I think you're better to go to the point of contact or the point at which the service is operated rather than going through all manner of other people.
Yeah, there's several services.
Sorry, I can't hear you there, Eric. You there?
Yes, I'm here. Can you hear me?
Yeah, sorry, yes.
Yeah, there's several services. There's the Westpac, there's the RACQ, there's the state government emergency helicopters that fly over. There's not just one service that flies over, but like even on a calm day, they have a windsock there on a calm day. It doesn't seem to make any difference, you know. It's so I can understand where if there's a wind in a certain direction, that might be a contributing factor. But on a calm day, I can't see any reason why some minor changes couldn't be made.
Right. Well, the other thing I could suggest you do, Eric, is get onto your state and federal members of parliament and see if they can intervene with you with the appropriate authorities. All right, then?
No, I'll do that. But thanks very much for your advice.
All the very best, Eric. Cheers now. Time on 4CRB, 23, coming up to 24 minutes past 9, as we say our good morning to Jan. Good morning, Jan. How are you?
Good, thank you.
How can we help you today?
I'm interested in knowing about a due diligence clause in a contract when purchasing a property and how vital it may be.
Well, it's a question of whether it's needed or not. Normally a due diligence clause is put into a contract when there are things that you wish to investigate that are important to you in relation to the acquisition of a particular property. And so depending on how broadly the due diligence clause is drawn, it can in fact provide an absolute escape from the contract for a prospective buyer. So whether you're the seller or the buyer, you may want the due diligence clause drawn in a different way. If you're the seller, you would want the due diligence clause to be as tight as possible so that it's restricted to those things that the buyer claims are relevant. If you're the buyer and you're simply buying, but you're wanting to ensure that you can get out without too much difficulty, then you would want to draft the due diligence clause in much broader terms.
So there's several ways of drafting
Certainly
a due diligence clause.
Yes.
In this particular case, I wanted the due diligence clause put in because there was an existing property and they have built a second property on the same piece of land under the same title.
Right.
But I wanted to make sure that it was all council approved.
Yes.
So I wanted a due diligence clause in primarily for that reason, but the seller does not want the due diligence clause and tells me it's unnecessary.
Right. Well, the only other alternative then would be to put a clause in which says this contract is subject to and conditional upon the buyer confirming with the local authority that all improvements constructed upon the property are fully approved and compliant with council requirements, failing which the buyer may at their option terminate the contract. So you can narrow it down, but Jan, don't take what I just said as legal advice. It's not. You would need to have your lawyer draw the clause in a form that is going to be acceptable for you. All right, then?
Okay. Thank you. Couldn't I make that inquiry myself through council? Could I?
You very well may be able to. You can contact the council and see what they can tell you.
Okay. Well, thank you very much for your time.
All the best, Jan.
Thank you.
And we'll say a very quick hello to Val. G'day, Val. How are you today?
Oh, hello.
Yes, how can I help you, Val?
Oh, look, it's just a quick question.
Sure.
I moved up to Queensland from New South Wales 7 years ago. And before I left down there, I had a power of attorney. But I've also had a new will at the public trustee here. But and they didn't suggest anything to do with power of attorney. They said leave that. But my sons up here and they're both executors and everything of the will and the power of attorney.
Yep.
Would it be advisable for me to get power of attorney up here?
Well, the thing that you need to check if you did your power of attorney in New South Wales, Val, is that there are two documents you need to do in New South Wales. You've got an enduring power of attorney and an enduring guardianship. So if you didn't do both, if you only did the enduring power of attorney, then I would recommend that you do get a new enduring power of attorney done in Queensland, because the Queensland form allows you to appoint an attorney for financial as well as personal and health matters, whereas in New South Wales, unless you've done the enduring guardianship form...
No, I didn't.
Yeah, the enduring power of attorney in New South Wales is only for financial matters. So I would suggest to you that it would be advisable for you to get a new enduring power of attorney done up here in Queensland.
And the guardianship as well?
Well, the guardianship is included in the one document in Queensland. So the Queensland form is enduring. It's an enduring power of attorney, but you have the ability within that document to tick a box saying, I'm appointing these attorneys for financial matters. I'm appointing these attorneys for personal and health matters. And if you wanted to appoint different people for, so one set of people for financial and one for personal and health, you can do what's called a long form power of attorney in Queensland, where it's possible to appoint different persons for those different tasks. But if you're just intending to appoint your two sons as your attorneys for all matters, then you would use the short form. And short form being said, I think it goes to about 12 pages, so it's not short. But that document will do you for financial as well as personal and health matters.
Oh, thank you so much. Thank you. That has answered my question perfectly.
No trouble at all, Val. All the very best for that.
Okay. Thank you.
Bye
Thank
now.
you.
Well, thank you to all the people who've called in today and made for such an interesting program. I might carry forward that topic of the Advanced Health Directive until next week, so we can talk about that then. This is John Fradgley from the Bell Legal Group. It's been great to have your company this morning. I'll look forward to being back with you next week. But as always, until then, it's goodbye and God bless.